All right, we'll let people filter in here. Give it about 30 seconds. All right, I think we're ready to start this thing. So welcome all to the latest edition of the SEMA Future Leaders Network Lunch and Learn program. Today, we're going to be covering protecting your patents, brands, and innovations. I am joined by two amazing presenters who are passionate about their field and are ready to share some great information with you. One of the first presenter that we have with us is Mr. Jeffrey Banyas, a shareholder and manager of legal production at Sisson and Banyas Attorneys at Law. Jeffrey is a licensed U.S. patent attorney and manages day-to-day operations. Utilizes his experience growing up as a son of small business owners to advise clients on all aspects of intellectual property law. His practice encompasses licensing, negotiations, enforcement, patent drafting and prosecution, trademark filing and prosecution, e-commerce, trade secret documentation, and copyrights. While no longer active, Jeffrey spent 17 years driving quarter midget sprint cars and super modifieds at circuits around the United States. The mechanical experience he gained during that time serves Jeffrey particularly well with his customers in the automotive sector. The other great presenter that we have with us today is Mr. Ifti Zaim, counsel at Irwin IP, now part of Miller Johnson. He primarily directs his practice towards utility and design patent litigation, patent validity challenges before patent trial and appeal board, intellectual property related customs disputes, and trade secret litigation. Most recently, IFTI managed and served as second chair in the landmark case of LKQ versus GM. IFTI also assists members of the arts and entertainment industry with their intellectual property needs. We thank them for being here today, and they have a great presentation for us coming up.
Thank you, Dallas. Pleasure to see everybody. I see some names and faces in the audience that I've known for many years here, and hopefully this will be a good presentation for everybody. I'm Jeffrey Banyas. As Dallas said, I'm the manager of legal production for Sisson and Banyas. I'm going to spend most of my part of the presentation here more on securing your intellectual property rights, whether that's trademarks, patents, copyrights. IFTI will be jumping in when we get to enforcing and defending against enforcement actions. And so I know we have some limited time here today. I thank you all for your time, so we'll jump right in. From a foundational standpoint, I always like to start these presentations with what exactly is intellectual property? Why does this matter at all? And I can give you the clinical definition of what intellectual property is. I'm not going to read it for you guys. You can see it on the screen there. And it's largely meaningless for most people in a business sense. When we talk about intellectual property as a business asset, the things that we're looking at is gaining exclusivity over your brands, your products, your creative works, and protecting your market share. Those are the things that really make a difference for a business when we're talking about your intellectual property. And if you think about it in the current context of the technology that is out there for us today, any of you that have worked a booth at the SEMA show probably know this. It is easier today to gain access to and copy products and brands than it has ever been. Between AI technology, scanning tools, e-commerce tools, there are more people who are watching your product releases, your brands, than ever before, and there are more people that are trying to take your market share, take a portion of your market share by copying your products and cutting you out of that. Intellectual property rights, everything that we're talking about today, those are the tools that we use, that FD and I use on a day-to-day basis to make sure that those types of things aren't happening and that they aren't impacting your business in a way that's going to stunt growth or in worst case scenario, shut you down. And I know I'm sure FD deals with it all the time as well. You know, these are rights that are created by an action that you have to take generally. I probably get 3 or 4 inquiries a quarter of, hey, somebody's copying my brand, somebody's copied one of my products that I just released last year. I need you to help me do something about it. And the first question I'm always going to ask in those situations is, well, what intellectual property rights do you have? Do you have a patent? No. Do you have a design patent? No. Do you have a trademark? No. Copyright? No. If you don't take some proactive steps to protect these things, you know, FD and I are very, very good attorneys, and there are a lot of very good attorneys out there around the world that practice intellectual property, but we're not magicians. We can't just pull rights out of our hat when none exist. So these are things, as we're talking about them, you need to be cognizant of. There needs to be some proactive measure on your part to protect these things so that we can protect market share and we can protect your exclusivity over your brands, your inventions, your creative works. With that in mind, we'll jump right in. Protecting your brands. And we have this divided out between brands, inventions and innovations, and creative works. I always like to start by talking about brands because every business has a brand. Whether you realize it or not, you have a brand name, you have product brand names, you have logos. All of those are things that consumers use to recognize that a product or a service is coming from you as opposed to somebody else. And all of those things very much should be protected. At the very least, these are the things that you want to be protecting for your business and for your individual brand if you're in that space as a content creator or something of that sort. How do we protect brands? What intellectual property assets can we use to protect brands? Generally, we're talking about 3 things, trademarks, trade dress, and copyrights. Your trade dress, we talked about it. Your trademarks, we talked about it just a second ago. Your brand names, your logos, taglines, anything that a consumer uses to identify you as the source of a product or service. Trade dress, I think, is one of the most underappreciated intellectual property assets that's out there. We're talking about things like packaging design, product configuration, color, things that are outside of that brand name or logo that consumers can still use to identify a product as coming from you. And I always like to go back to the example of Coca-Cola, right? Great use of all types of different trademarks and trade dress. They've got the name Coca-Cola, they've got the logo in white with the script font, but they also have the red and white color. They also have packaging design. The next time you're in, say, a gas station or a grocery store, just take a look down the aisle at the bottles of different soft drinks. And you'll notice very quickly that Coca-Cola is the only one in that hourglass fluted, wasted bottle. You're not going to see Pepsi in that bottle. You're not going to see, you know, even Dr. Pepper or Sprite or other Coca-Cola brands in that bottle. And that is for a very good reason because Coca-Cola has trade dress registration on that packaging design, and they have documentation that shows that consumers have come to identify that as associated with Coca-Cola. The other thing that we use for protecting brands at times is copyright. This is particularly useful when you're talking about artwork, photos, videos that people use as brand identifiers. Keep in mind that you do have to have, and we'll talk more about copyright later on, you do have to have some creative or artistic contribution. Simply having a brand name and a specific font in Times New Roman is not going to be enough usually to get you copyright protection. The big one that we talk about primarily with brand protection is your trademarks, though. And selecting and using a trademark is really important. A lot of times it's a step that kind of serves as a little bit of an afterthought, and people don't really start thinking about how to protect this until they're a few years down the road. The first thing you really want to do is make sure you have a good marketing plan in place for how you're going to use your trademark. One of the biggest problems that we see is people who use trademarks inconsistently. Sometimes it's used in singular form, sometimes it's used in plural form, sometimes it's capitalized, sometimes it's not. You really need to have a plan and stick to it for how you're going to utilize your trademarks. And you want to select a strong trademark. Not all trademarks are created equally. You want something that is going to be unique to you. And generally, as you see there, we recommend that you have a professional search conducted to make sure that it is unique. And there are databases that myself and other intellectual property attorneys use all the time to help with that. But you also want it to be distinctive and not descriptive. This is one of the areas where I think people get in more trouble with trademarks than anywhere else, is there's a tendency to want to select a trademark that describes your goods or your services or as a generic term for your goods or your services. Those are trademarks that are generally not subject to protection or not subject to the same level of protection as a fanciful or distinctive term for your brand name. So think about in the context of the automotive aftermarket, if we said, um, tires, well, if you name your business or your brand Tires R Us, maybe the R Us gives you some distinctiveness, but it's not a very strong mark. It's got leads off with a word that is very descriptive of your products, and you're going to have a hard time registering that. You're going to have a hard time enforcing that. Which leads us to the last point there, which is to ensure that your mark does not become diluted and that you don't lose market share by allowing infringers to skate by. If you go 10 years letting every Tom, Dick, and Harry out there use your trademark without taking any action, without doing any type of e-commerce enforcement or customs enforcement like IFTY does and things like that, the value of your mark just keeps getting diluted more and more and more and more. And it can even become a generic term for your goods and services. Xerox has had this issue in the past. Velcro is constantly fighting against their mark becoming generic. You don't want your mark to become a generic term for your products, as flattering as that might be. So what steps should you take then to protect your brand? Number one, you need to be registering your trademarks. Technically, a trademark right comes into existence the moment you start using it as a brand identifier. Those that aren't registered are infinitely more difficult to enforce than those that are registered. And if you have your trademarks registered, you have the right to use that little R in the circle now. You shouldn't be using that unless your trademark is registered. That's another area that gets people tripped up sometimes. But now you have all kinds of different options for enforcement in federal courts, use on Amazon brand registry and other e-commerce platforms, customs and border protection, all the things that IFTY is going to talk about in a little bit here. that entire world of enforcement actions becomes much more open to you if you have your trademarks registered. Should also consider trade dress registrations for your product packaging and configuration to the extent that you have something unique. If you're packaging your product in a plain brown box, probably not something that's unique enough that it's going to be subject to trade dress registration. And then if you do have some artwork, something that is, again, more than just, your name in a specific font, it can be beneficial to go ahead and apply for copyright registrations on that artwork as well. The final thing that I'll say before turning it over to IFTY on the brand protection side of things is you should always be considering the international implications of your trademarks. I know there's plenty of people who, in the automotive aftermarket, who sell internationally. You have distributors set up in other countries. Those distributors generally are going to come looking to you if and when there's an infringer or a counterfeiter out there and saying, well, what are you going to do about it? And if you don't have the trademarks registered in their country, your options are kind of limited. So you really should be thinking about where does your business have or expect to have significant sales and distributors, and where might the counterfeit products be manufactured? A lot of times it's better off to go right to the source of where they're being manufactured and enforce there. Where might the counterfeit products be sold? And one of the big things that gets people tripped up a lot of times is in the United States, we have a requirement here that you have to be using your trademark in order to get it registered. That requirement doesn't exist in every country around the world, and the most notable one where it does not exist is China. And so you'll have what they call registration countries where anybody can register any trademark anytime they want. And then when you, as the legitimate brand owner, get to that country to try to register, now you're being held hostage by that individual who's registered their mark for you. So with that, I'm going to turn things over to IFTY for a little bit of a discussion about the enforcement implications of brand enforcement.
Actually, Jeffrey, we had a question here that I feel like now would be a good time. At what point should I consider getting my brand or product protected? Is there a time that's too early?
There's never really a time that's too early. In fact, I filed several applications today alone under what's called intent to use. And in the United States, once you've identified a trademark that you want to start branding your products as, and you're starting to take steps towards building out that brand, you don't even have to have a product in the market yet under that brand name or under that logo. You can file what's called an intent to use application, and that will plant your flag in the ground so that somebody else can't kind of beat you to the trademark office with their own application on the same or similar brand name or logo. Very good question. Something that comes up pretty frequently. IFTY?
All right. Hey, everybody. My name is IFTY Zaim. It's a pleasure to be here. Thank you very much for inviting me, and I'm honored to speak in front of all y'all. So you might, before I get started, you might be thinking, well, wait a second. Jeff's a lawyer, IFTY's a lawyer. What's the difference? And it's a little bit of a fuzzy answer because we both do play in each other's lanes a little bit. But primarily, I'm a litigator. So if you think of it this way, your intellectual property rights are like your fighter jet's missiles, right? Jeff builds the missiles. I'm the guy you stick in the jet to go and shoot him. So, and there's a question in the chat that I do want to hit right off the bat. What if I'm not currently protected and someone has already knocked off my product? Is it too late to get protected with the trademark? The answer is not necessarily no. You might actually be okay. You might have lost some rights. Trademarks start accruing protection pretty much as soon as you use them in the US. So using a mark in commerce gets you local trademark protection rights. That's not the same thing as a federal registration for all the reasons Jeff mentioned. A federal registration is much better and it gives you nationwide rights. But you already start accruing rights in your market. So as long as you can show that you were first in your market, meaning geographic market, product type, you'll have more limited protection, but you can still have protection in the zone where you were first. It's harder, it's more expensive, it's not as neat as having the registration, but you're not out of luck. So diving into dealing with infringers. Let's say you got somebody who's infringing your trademark. You've got your mark registered because you listened to Jeff, you did what he said, you went to the patent and trademark office, and you went and registered your trademark right when you were establishing your intent to use. Then you converted it to a full registration. First thing you want to do, make sure all your paperwork's in order. Make sure that the right entity that can actually enforce the trademark owns the right to enforce that trademark. Make sure that the registration's valid, that you've got everything, all your ducks in a row. Make sure that you're actually using your product in commerce, because if you're not using your product in commerce and you come around trying to enforce the trademark, that creates risks of someone trying to trigger an abandonment defense against you, because trademarks exist while you have use, basically, that trademark rights accrue from using things in commerce. And make sure you actually have priority, meaning make sure you were first. Because if it turns out you weren't first and you sue somebody, not only do you lose, you might lose the right to use that name on that product if they had superior local rights on that product. So there's a lot of things you want to kind of checkbox before you walk into the arena to lay down the law. You also want to verify infringement, make sure you got a good case. So you want to check a few things. First of all, are the marks actually similar? Because the end all be all of trademark infringement is confusion in the marketplace. Somebody sees a product on the shelf and they think, who made that? And if the fact that there's a similar trademark on the product is causing confusion as to who made that, that's grounds for stopping the later user from using it, because the first user already kind of put their name on that product. They're entitled to that goodwill, not the follower. You want to make sure they're on similar goods and services, because there's not necessarily going to be confusion, even if there's a very similar name on very different products. The Domino's sugar case comes to mind. Domino's pizza, Domino's sugar. You're not going to think they're coming from the same place. The use in commerce also matters. Make sure that they're actually using the thing, because that's a much stronger case, and show that confusion is likely. And the first most cost-effective step, since there's a lot of questions about cost, is to send a cease and desist letter. This basically consists of going to an intellectual property lawyer, saying, hey, here's my brand, here's my trademark registration paperwork showing that I own this. Here's when I started using this, and here's my product on the market and what it looks like and how it's marketed. And here's this guy coming in after me and peddling off my goodwill, taking advantage of the fact that I've cultivated a name in this market, and they're basically stealing that value proposition. Okay. And you go to your lawyer with that information together. It'll make the process a lot more efficient, because then the lawyer can analyze it all in one shot. Look at the evidence of your brand, look at the evidence of infringement, and figure out what to do. Then the easiest way to deal with it first is to send a cease and desist letter. And there might be even easier ways if you're dealing with like Amazon Marketplace that cost even less. But you can have your lawyer draft up a letter. It shouldn't take too much time. It's really hard to pin a number on it, because sometimes you just need more investigation to make sure that you actually have a good case. You never want to send a letter on a bad case. It puts you in a bad situation. It can actually hurt you. So you want to be doing your homework. And sometimes that takes a few hours. Sometimes it doesn't. Some law firms offer like a flat rate for sending a cease and desist letter, and some will do it hourly. Usually, just so you guys know, the flat rates account for the uncertainty. So you might actually end up paying more for a flat rate than you would hourly. You might end up ahead. Sometimes the certainty is worth the slight increase in cost. But law firms are basically taking a guess as to how much we think this is going to cost and doing that, and setting their flat rate based on that. So whether you're flat rate or hourly, you'll probably be out roughly the same amount of money. And I would imagine that you're talking 4 figures, not usually 5 for something like this. And sometimes it's just a few $100s if it's a really clear-cut case and you can just bang out a form letter, confirm everything's in order. Sometimes it needs a bit more investigation. And in that cease and desist, you tell them what you want, whether you want them to stop, whether you want money and damages because they diverted sales from you, whether you want their profits because they're a flagrant, blatant, willful infringer who just straight up took your name and they're trying to steal your customers by misleading them into buying their products. Do you want attorney's fees? And you can lay that all out in the letter. And if we could jump to the next slide. So let's say the letter doesn't work. When the letter doesn't cut it, what do? Well, you got a few options. You can go to the courts, litigate in district court. You file a lawsuit against them in ideally federal district court. There is such a thing as state trademark rights, but it's complicated and weird, and we won't go there. The most trademark litigation happens in U.S. federal district courts in the United States. And you will basically allege trademark infringement and proceed with the lawsuit. This can be quite expensive. And depending upon how far the lawsuit goes, it can cost quite a lot of money. Most 99% of lawsuits will settle at some point, but a settle means you met in the middle some way, somehow. So if you're like a clear-cut winner, then really you might just be like, you might get a quick win. You might get them to stop right off the bat just when they see, oh, they sued us. Okay, they're serious. We're losing. We're not going to try this. We're not going to play this game. You might be in for the long haul, so you got to be ready for it. Now, a faster route might be to register your mark with customs. Customs will enforce at the border. If the product is imported through the borders, customs does enforce trademarks, and we'll get into an example of that in a second. And then Uncle Sam's helping you out with the process of enforcing that trademark. And it is quite cost effective to get something seized at the border. And as we'll get to in a second, for better or for worse, it causes a massive headache for the other side once customs starts seizing their stuff, because fighting customs is not the same thing as fighting a private party. And third, if you're fighting another trademark owner, someone's trying to get a mark registered on something similar to you, you can fight them in front of the USPTO. You can file a cancellation request, say, hey, someone's applying for a trademark that's close to mine. You shouldn't grant that, and try and get it shot down. And if we could jump to the next slide. All right, so trademark litigation defenses, and just in the interest of time, we're going to blaze through this. Let's say that you're on the other side of the coin. Someone's coming at you and saying, you're infringing my trademark. Well, there's a few things you can do. First of all, you can challenge the mark, right? Marks are not necessarily impenetrable. Sometimes they acquire a status called incontestability after a certain amount of time in commerce, meaning they've got some presumptions that go their way to protect that mark because it's been registered and in use for a long time. So the law knows it's got some intrinsic strength. But you got to look, is their mark actually registered? If it's not, then it's a whole lot weaker right off the bat. Is it incontestable? Meaning, how long has it been out there? And you can talk to a lawyer about whether or not the criteria for incontestability are satisfied. Is the mark weak? Is it merely descriptive? Has it become a generic, like escalator, where it doesn't matter if it's an Otis escalator or back in the day, an escalator? That's not a word used to identify a brand. That's a word used to identify a product category. And you can't take that away from consumers. So, and were you actually using the thing first? That matters too. Because if you were using the thing first, then you've got a pretty good hook at keeping your name and taking theirs off. So check out whether you can challenge the mark. Challenge authorization. Did you have a license? We'll get to that in a second. Had the owner explicitly or implicitly permitted you to use that name? Was your use a fair use? There's two types in trademark generally, descriptive and nominative. And to get away from the legalese, descriptive fair use basically means I'm allowed to use this name to describe a product. Now, there's restrictions on how much you can use. You have to use the least amount that you need, but you're allowed to fairly describe something in the market using their name. Nominative fair use means you can name a product in the market in certain ways. Again, there's nuances, there's restrictions, but it might be available as a defense to protect you in the event that you can't shoot down the allegation of infringement anyway, or you can't shoot down the mark. And also, did they wait too long to sue? There is a time limit. And there's a doctrine in law called latches. We like to give things fancy names. I can't help it. And if someone sits on their rights for too long, then the question is, did they sit for just too long? Like, did they almost bait you into continuing to use this thing, run up damages, run up your reliance on the mark? So now it's real expensive for you to drop it. And then they come with their lawsuit when they know that, okay, now we got leverage. Now they need this name. That's not okay. That's not allowed. So you can challenge on that basis. Is it a high probability shot? Not necessarily. You want other arrows in the quiver, but it's there. You can also challenge infringement. You can just say, no, my mark's different. No, my goods are not the same category. No, there's no likelihood of confusion. Look at these surveys. Consumers are not confused. Look at the product types. They're different. They're totally different tiers of the market. Look at the distribution channels. You don't find these products in the same place. The customers are sophisticated. They buy these things by drafting a 10-page purchase order. They are not confused as to who they're buying from. Those are all defenses against infringement. And if we could jump to the next slide. Thank you, thank you. All right, so, and wouldn't be complete without some more stories. So I'll try and keep it real tight so we don't go over on time. So one case that comes up in the trademark context, this was actually a defensive matter. Remember I said we talk about how customs can go wrong and how it can be a real pain. Well, this is how. So we represented a company called US Auto Parts Network, and US Auto Parts Network are great people. It's a good company, fantastic company, good people. It employs hundreds of Americans from coast to coast, and their primary business at the time, at least, consisted of importing and selling repair and replacement parts. Now, these included auto grills. Now, some of you in the industry would know almost all replacement auto parts are manufactured outside the US. They all come through a port, quite often made in Taiwan. And these were licensed parts. They had deals with automakers. They were licensed. There were contracts inked allowing US Auto to do this in exchange for things. And some of the products US Auto imported included grills, replacement grills. And these were sometimes protected by design patents, or they had placeholders for a logo to fit in. They did not actually have the logo, but they had placeholders for the logo. And again, these were licensed replacement parts. Well, at some point, customs decided, or the customs at a specific port decided that they were going to start seizing US Auto shipments because they thought these grills were counterfeit. These grills made up less than 1% of the contents of US Auto's containers, but customs started seizing all of them, every single container, and then holding it subject to a single entry bond requirement. Now, what's a single entry bond requirement? Single entry bond requirement means you need to submit a bond for each shipment in order to get it released by customs. And you can normally get a bond underwritten, but the problem was they wanted a bond in the amount of 3 times the commercial value of the goods. Now, anyone who's dealt with customs shipping or underwriters knows there ain't no underwriter on the planet who's going to write you a bond for 3 times the value of the thing they're bonding. And they had to do it for literally all their products. So we basically got engaged to try and help them out of this pickle, because as you can imagine, getting your entire Eastern Seaboard's worth of shipments seized is not good for business when you're an importer exporter. So we had to figure out, okay, well, what do you do about this? We talked to customs lawyers. That didn't help, because it turns out the customs lawyers do not actually litigate against customs. They just negotiate, and customs was not in a negotiating mood. So we had to figure out, okay, well, we got to sue them. We got to file an emergency lawsuit. Well, there's no roadmap for how to do that, because people don't sue customs often, because it turns out it's really, really, really hard. So we have to figure out what to sue for, where to sue, how to sue, meaning what procedure and rule do we sue under? None of this was really written down. We basically sued for an injunction in front of the Court of International Trade, asking the government to stop. And the court did issue an emergency order telling the government to stop, saying, no, less than 1% of the goods are counterfeit. You can put a 1% bond. Well, customs being customs decided that 1% could be multiplied by 3 because it was willful, then 3 again because of something else, and then by 9 because of the number of months that the parts were coming in. And so 1% actually meant 71%. And once we got over the shock of that math, we went back to the court and said, Your Honor, you said 1%, they're saying 71. And customs fought, we fought. Within about a month and a half of when this whole thing started, a month, we got an injunction saying, no, 1% meant 1%. And on the stand, we got the port director to admit that he knew this bond requirement was going to put the company out of business, and he did it anyway. And let me tell you, the judge was not particularly pleased with that admission. So we got in an injunction pretty much in record time for this. But this was a Herculean lift. When, I mean, Jeff said, we don't pull miracles. Not to be too up about it, but I would say that what we managed to pull in this case was pretty much a miracle. There was no roadmap for doing this. And frankly, I don't think anyone expected this to even be reasonably possible to get out of this pickle this quickly. Like, I truly wonder if customs was trying to run the company under the table before the courts could catch up and bail them out. But fortunately, that didn't happen. So that's the war story. Back to you.
Yeah, so I'll try to, I know we spent a lot of time on brands there. I'll try to speed things up a little bit as we start getting into inventions and innovations. A lot of you are making new products out there, bringing new products to the market. How do you protect those? Well, you're looking at 3 things really. Utility patents, which are going to protect how what a product does or how it functions. Design patents, which are going to protect the aesthetic appearance of the product. And trade secrets that are going to protect confidential information that derives economic value from keeping it secret, like manufacturing processes and things like that. What makes something patentable? In general, there's 3 requirements for patentability. Your invention has to be new. You'll hear this referred to as novelty sometimes. Think of it as, has anyone out there in the quote unquote prior art done exactly what you've invented, down to the T? Generally, if you've got an issue with novelty, you're not going forward with filing a patent application. The second requirement is obviousness. You'll hear it referred to sometimes as inventive step. Think about this as, you know, there's something out there in that prior art that's very close to what you've done. And would it be obvious to a person of ordinary skill in the art? And that's where guys like Ifty and I have to spend a lot of time arguing with the patent office and the courts about who that person is. Would it be obvious to modify that close prior art reference to arrive at what your invention is? A lot of wiggle room within obviousness to argue for patentability. The last requirement is what we call the utility requirement. Basically, if your invention can do anything at all, basically more than serve as a paperweight, you're going to be able to meet that requirement. So when should you take action? You think you've got something that meets these 3 requirements. What are you going to do next, and when should you act? I know this came up in the context of trademarks. When should you take action? Even more so with patents, you need to take action as early as possible. As soon as there's a public disclosure of your invention, and that could be another patent application filing, it could be a social media post, it could be a display at a trade show. Lots of different things can count as a public disclosure. As soon as that happens, your clock is ticking. And in some countries, you'll have a grace period of 1 year after that first public disclosure to file your patent application. In other countries, like if you've got major sales in Europe and you want to go to the European Patent Office or Germany or the UK, the day that public disclosure happened, you are no longer considered new and you are no longer considered patentable. One of the questions that comes up frequently for me is, what should I do? I've scrolled past it. What should I do about disclosure? I've got something that's not going to be real easy for my competitors to reverse engineer it. I don't want to disclose to my competitors how I'm making it. Should I file a patent or should I not? A patent does require that you fully disclose how to make and use your invention, and those rights in your patent, they are limited. They're limited to 20 years from the filing date. Once those 20 years expire, your patent expires and it goes back into the public domain. The benefit to a trade secret is you're not having to make that public disclosure. Everything is locked down. Think about the recipe for Coca-Cola or Kentucky Fried Chicken and all the legends and myth and lore that is behind the efforts to keep them secret. That trade secret lasts forever so long as you maintain reasonable efforts to keep that information a secret, labeling it properly to your employees and your vendors, restricting access, having proper NDAs and confidentiality agreements. So inventions that are very difficult to reverse engineer, inventions that your competitor can't just take off the shelf and say, yep, I see how IFTY's doing this, that, and the other thing. I can reverse engineer it and make my product. They generally are maybe a little bit more better protected by a trade secret with one caveat. A trade secret protection is not a substitute for patenting. So if somebody else independently develops your invention, if somebody else independently figures out the formula for Coca-Cola, and they've been trying for years, without you knowing any of your trade secret information, without improperly accessing it, you've got very, very little recourse to enforce. Your enforcement efforts on a trade secret are all around enforcing the confidentiality agreements, the agreements with your employees, people who had access to that trade secret or who improperly accessed the trade secret. It's not going to prevent somebody from independently developing your invention. And I'll turn it over to IFTY again on the enforcement side of this.
All right, Jeff blazed through that section in record time, so I'm going to try and keep pace. So let's say that you've got a patent, right? And you're looking at enforcing it. Well, there's patents and there's patents, right? And it matters. Not all patents are created equal. Now, when you're getting your patents, you might want the broadest claims that covers the most things. And, the tendency, although this is not allowed under the rules, you're required to be candid with the patent office, is to think, well, I don't want to go digging through the prior art because I might find something bad. Or I want to claim a little more so that it's a more imposing patent. As your patent litigator, when I'm in the position of wanting to go out and enforce your patent, I don't want that. I don't want the blunderbuss of a patent or the shotgun that's hitting a whole wide swath. No. We want the rifle. Because remember, I'm the guy you're putting in the jet. I don't want you to be loading 8 missiles on there and being like, yeah, none of them are really great. Just fire them all and, see if one of them hits. No. That's bad. I want it to fly true. I want it to be clear. I want it to be clearly directed at the thing that is actually your invention. And ideally, the other guy's clearly copying your invention. And I want it to be one shot, one kill. And when the other guy sees it coming, I want it to scare the bejesus out of them. So they know, oh, that thing's got our number. We better pay these guys out or this is going to be bad, because that saves you money. It saves you a lot of money and a lot of time. And ultimately, that's the patent you're going to be happy with. There's different philosophies on how to draft a patent application, but my philosophy as primarily a litigator is that I like them to be narrow, focused, and right on the numbers. Another important note, mark your products. There's a process called patent marking. You might have seen this on a product sometimes, where it says US patent number, blah, 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 or patents and a URL at a company's website. And then when you go to that URL, you'll see a list of products and a list of patents. Typically, it's the right way to do it, where it matches product to patent. This is very important because if you do not mark your product, then you are not entitled to damages until you notify the other side in writing of your patent. So that means that you find an infringer on the market and you look back and you're like, oh man, they've been making this infringing product for 3 years. Well, were you marking your product? Because if you were marking your product, then you can go back through those 3 years and collect your damages the whole time. If you weren't marking your product, then you got to send them a letter, and you only start to accrue damages on the sales that happen or the infringement that happens after that letter. So you can lose out on a ton of money by not properly marking your patents, your products. Now, let's talk about infringement. So in order to infringe a patent, you need to practice every single element of what are called the claims. If you look at a patent, the claims are at the bottom, and they're usually like a numbered list with, and they'll look like a cycling vehicle with a wheel, pedals, a seat, and handlebars. And in order to infringe, a product needs to have every single thing that the patent claimed. So if you look at figure 1 on the right, that's figure 1 of our hypothetical bicycle patent. It's got a wheel, pedals, a seat, and handlebars. Now, I forgot a product B label, I'm sorry. So at the top is product A and at the bottom is product B. Now at the top is product A, which is that bicycle with a bell on it. And at the bottom is product B, which is that bicycle without handlebars. Now, we're going to blast into the chat real quick if you guys want to. If you think product A infringes, and if you think product B infringes. So we're going to take 10 seconds, take a quick look.
And if in the meantime, we had a question in the Q&A that fits well here. Do product marks need to have the patent number on it, or only a note that the product is patented?
They need the patent number, but
Okay.
if it's impractical to mark a certain product directly, say it's very small, or say it's not got any non-aesthetic faces, right? You don't want to be sticking something on there. You can mark the packaging if it's not practical to mark the product. If it's, and if you use, but the key is that when you mark the packaging, you have to say the patent number, or you need to do what's called virtual marking, which means you give a URL for where they can find a table that pairs the product with the patent number. It's not enough to just say this is patented. You got to give them the number. Whether it's on a website or whether it's on the product itself or on the packaging. All right, so, and let's give the answers to this. So product A does infringe. It may have a bell, but it still has a wheel, pedals, a seat, and handlebars. So it infringes. Product B does not infringe. It's got a wheel, it's got pedals, it's got a seat, but it doesn't have handlebars. If it's missing one element, it doesn't infringe. All right, next slide, please. All right, now, anticipation and obviousness. Jeff touched on this a little bit. Let's talk about it a bit. Anticipation is there was literally something that had that exact thing in the market before. Obviousness is, well, it wasn't exactly there, but a person of ordinary skill in the art could envision it. That an ordinary engineer who designs things of this type could imagine this. So you didn't really contribute anything to human knowledge when you patented this thing. Now, let's say that you decided that, you know what, I really want to get that bicycle with no handlebars. I want that patent. I want that covered under my patent. So I'm going to get rid of the handlebars limitation from my claim. I'm going to just claim a cycling vehicle with a wheel, pedals, and a seat. And this is the problem with that. Yes, you got the bicycle. You got the one with no handlebars. It now infringes. But in the prior art, before you applied for your patent, there was a unicycle. And this unicycle has a wheel. It has a pedal showing, and it has a seat. And because of the way you broadened your claim, that unicycle is now prior art to your patent. And if the pedal shown on the unicycle is deemed to be, quote, pedals, then it anticipates your patent. And even if the unicycle was only depicted with one pedal and you don't deem that to mean, quote, pedals, it's still probably obvious because any person who designs cycles knows that if you stick a pedal on one side, you best stick a pedal on the other side. So it's got pedals. So be careful with your claims. If you claim too broadly, yeah, you might get more. But if there's anything before you that did that thing that you just broadly claimed, well, that's coming up to shoot you down. So watch out. All right, next slide.
And in the interest of time, we have about 10 minutes left, and I do want to make sure we get to questions. Just a reminder.
I will actually sharply curtail this war story then. So this is the landmark case that Jeff referred to in the beginning. And it basically consisted of a representation for LKQ Corporation. That was our client. Most of you probably know who they are. They were the largest distributor of aftermarket and repair parts in the country, against GM. Now, 15 years ago, several automakers started embarking on a strategy of design patenting every single part of their vehicles to try and monopolize the repair market. And you're only entitled to a patent when you contribute to human knowledge. I think we can agree that the 2019 Chevy Equinox was not a dramatically innovative vehicle design worthy of like contribution to humanity and a monopoly, as shown by the fact that a Chinese vehicle, the Lian S3, had virtually the same design before. Now, the law of design patents used to be very stilted towards granting a patent to anything. The short of it is, we decided that that law was wrong. So we challenged these patents. We lost, and we appealed. We lost again. We asked for a full appeal in front of the full Federal Circuit Court of Appeals, which is granted once in 5 years on about 1,000 requests, so about a 0.1% chance. We got it, and we got 40 years of law changed to properly reflect that you need to actually invent something. You need to actually do something innovative in order to get a design patent, that it needs to be non-obvious to a designer of ordinary skill in the art. So that's that story. And and very briefly about Amazon. It's an expedited way of enforcing both trademarks and patents. You can register your trademarks and your patents with Amazon. It gives you a fast pathway to enforce them. Trademarks gives you some automated tools and monitoring functions. And if Amazon agrees with you that your trademark's infringed, then they might remove the product from the market for you. A lot faster than court. And the Apex system is the same for patents. You register your patent, you call out an infringer, they take a look at it, they say, yeah, we think that makes sense. When you do this, you have to you and the other guy have to put down a $4,000 deposit. The winner gets their deposit funded. So if Amazon decides, no, they're not infringing, well, as the patent holder, you're out your deposit, they get theirs back. If Amazon decides they're infringing, then they take the listing down, they give the patent holder their deposit back, and the infringer loses their deposit. And if you can't put up the deposit, you don't play. So that's the Amazon process for you. And back over to Jeff real quick.
Yeah, and I know we want to get through some questions, so I'll just go through this relatively quickly. The last area of intellectual property that we talk about, and a lot of this gets into marketing material, is copyrightable work. Anything that's written, like your marketing literature, your instruction manuals, your training materials, any photos or artwork or audio or visual, podcasts, promotional videos, those are all things that can be protected by a copyright. Like trademarks, your copyright protection does technically attach as soon as you make the work and publish it. But you do have the option to register it. And that option, as Ifty will tell you, opens up a whole new world of enforcement possibilities, including e-commerce takedowns and federal court litigation for statutory damages that has some real teeth to it. The one thing to watch when you're dealing with copyrights is generally the person who creates it is the one who owns the copyright, unless and until it is assigned over to your company. So if you've engaged a third-party content creator to make a video for your social media, you need to make sure that your company is getting the ownership of that copyrighted material from the content creator so that you have some rights to enforce if and when the need comes up. And I'll turn this over to Ifty then for how is copyright infringement different?
All right, so super quick. The big difference for copyright infringement is that infringement requires copy. It's not enough to just be similar. You need access and substantial similarity, which is different than patents and different than trademark, which only care about whether you practice the claims or whether it's similar. And we can jump to the next slide. And my tips are register your copyrightable works. It's a prerequisite to enforcement. You can't enforce a copyright unless you get the federal registration, and that can seriously slow you down if you're trying to enforce. It also opens up statutory damages. Just per infringement, you're entitled to from X dollars to X dollars. You don't have to prove damages in order to get that entitlement, which is huge. And fee shifting, meaning your lawyers get paid by the other guy. You want to get a license to use the copyrighted work of others. Don't just use things you find on the internet. It gets people in trouble. It's a lot cheaper and easier to get permission first. This is not a situation where it's easier to ask for forgiveness. It is not. And last, AI tools are great. Frankly, everyone should be using them. It's a modern competitive necessity if you want to play these days in the market, not just because you work cheaper. It's because your decision loop is so much faster than someone who's doing everything by hand. You can go from information to decision in a snap, but be wary because AI can infringe copyrights because it's just pulling information from all kinds of things. So make sure that if you're going to use something that AI generated, that it's not infringing someone's copyright.
And on that, there was a question in the chat that just came up right before we got to that section, and it was, are you able to copyright AI generated or modified images and media?
I mean, that's an open question.
It's a tough question, and it's an open question right now that the Copyright Office and the courts are still very much dealing with. I can tell you the Copyright Office generally says that AI cannot be a copyright creator. So there does have to be some level of human contribution beyond just, you wrote a prompt that generated some image or some video that would otherwise be copyrighted. But it's one of those things where, as we often see, the courts and the Copyright Office are kind of struggling to get their arms around it. I wish I had a better answer for you.
I don't think there is a better answer. That truly is how it be right now. It's an emerging area of law, and we're trying to figure it out. And it's one of those areas of law that moves so fast that it's literally outpacing the court's ability to figure it out. So,
and I know Ifty talked a little bit about some costs on the enforcement side. To give you guys an idea of costs on some of these things, generally our firm does operate on a flat fee for filing and obtaining these rights. If you're talking about a trademark registration federally, the cost generally is going to be somewhere around $1,500 to $2,500 to get through registration on a pretty clean registration where we don't have to deal with a lot of back and forth with the trademark office. Your utility patents generally are kind of the most sought after component and also the most difficult to obtain. We tell people over the full 20-year life of the patent, expect to spend between $25,000 and $30,000 on a US patent. Most of those costs are front-loaded. On a design patent, you're probably talking closer to $5,000 to $8,000. And copyrights, I tell people, think of your copyrights as your lottery tickets. They're very easy to obtain. The cost is relatively low, often, $500 to $750 or so relative to a trademark or a utility patent. And as Ifty said, when you start talking about those statutory damages of up to $30,000 per copy, they can have some big payouts at the end if somebody intentionally copies them from you. So I hope that helps to answer that question. I know I saw it pop up a couple times in the chat.
and one other question in the chat from Brian Elder. If you find a patent in a prior country that looks a little risky, looks a little spicy, you're not sure if it really is a problem, what steps should you take? You should reach out to patent counsel in that country. You should ask them for their opinion because the laws are different from country to country. You want to reach out to a patent lawyer in that country.
Yeah,
ask them about it, assuming you're going there. And then if you decide to go forward and there is a certain amount of risk, then you might want to obtain what's called an opinion of counsel letter, because that can provide you some amount of protection against at least basically a letter from the lawyer saying, I don't think you infringe. And that provides you some amount of protection against damages later, at least under US law. Again, foreign laws, different game sometimes.
Yeah, and just to tack on what FD said, that's absolutely what we would normally do if we're looking at going into that country and we're concerned about infringement. The other part about a patent in another country is it does still serve as prior art in the United States. So prior art in the United States is not limited to United States patents or disclosures that happened in the United States. So if you find that patent in another country and you're considering filing your own patent application in the United States, know that there's a good chance that that patent's going to come up and potentially render your claims non-patentable.
And there's a couple questions that I want to get to. I know we're running a bit long, but one of them is like pretty industry specific and revolves around wheel design. Is it possible to protect wheel design?
Absolutely. As long as they meet those three requirements, that it's a new design, it's a non-obvious design, it's not an obvious variation on an existing design. Yeah, you'll absolutely be able to get, and there's plenty of, probably thousands and thousands of wheel design patents that are out there in the market.
And if you happen to be a wheel design company that does variations on a similar design theme, right? A common motif that you repeat through your wheel designs and nobody else does it. Over time, you can even acquire what's called trade dress protection, which basically is similar to design protection in some ways because it does attach to the design. It's saying that when consumers see this wheel on the market, they know it's your wheel. From the design, they know it's your wheel. So therefore, the person who makes that wheel is entitled to exclusivity as to that wheel because anyone's going to be confused if they see something that looks like it because they've been the only one making that for a while. So that's also an option in case you have like a design motif or a particular emblem or something that you put on your wheels or a certain look that you think is unique to you. You can acquire trade dress protection on it with enough time in the market.
Then we had a question from Dan. When creating a new product for the market, is it wise to submit trademark and patent applications at the same time, or what would you do in terms of order?
Best practice in my mind is if you're looking at a product and let's say you've got a brand name over that product, get your brand name filed as soon as possible, get your patent application filed before you disclose. So your trademark registration, you want these things to be registered and granted as soon as you possibly can so that when people see your product and start trying to copy it, you've got some recourse to go after them. In our industry here, this is, product life cycles often are relatively short. You don't want the clock to be running out waiting for your patent to get granted or your trademark. Now, if you're talking about like what IFTY talked about, getting a design patent and then getting a trade dress registration, you are going to have to do your design patent first and have some period of time where you're selling and the market becomes accustomed to your particular design as a brand identifier to you. It's not going to be easy to make that argument at the trademark office, but you are going to have to stagger those by several years, most likely.
And then in the interest of time, there have been some great questions and we thank you for your guys' time to present. A great question to end on would be, if I'm interested in having a discussion to protect my brand or product, what information should I bring with me to the first meeting?
So I actually touched on that a little bit a little earlier. If it's a brand and you're looking to protect it, you want to make sure that your registration materials are ready to go, which means what's your brand? What name do you want? What categories of goods and services does it cover? Is it already being used in the market? If it's not, how are you going to use it and when are you going to bring it to the market? If it's not in the market, if it's in the market already, what distribution channels does it come through? Where where does it go? What type of customers? All that information helps the attorney quickly
Yeah,
establish protection.
and I would back that up. Generally, we're looking at what's the mark, when did it start being used, what goods is it being used on? When we get to the patent side of things, there's often a misconception that you need to have a prototype or you need to have, everything, all the bugs worked out before you can file a patent application, and that's simply not true. The US and most of the world now is under a first to file regime, which means the first person to get to the trademark office or the patent office and file a patent application is the one that's entitled to obtain the patent on that invention. And so you want to file as early as you can with what's called a provisional patent application. And to do that, I mean, we've filed provisional patent applications that cover little more than just a sketch on a napkin. You definitely want to get to your patent attorney as quickly as you possibly can. Whatever you have at the time that you think, you've got something that might be patentable here, get it in the hands of your patent attorney. They'll be able to ask the right questions if they need more information.
I would put one asterisk on that, and I completely agree with everything Jeff said. But I would put one asterisk on it, which is that your core invention, make sure you have it figured out at that time, not necessarily prototyped, but figured out, because I can tell you some real comical war stories about patents where the inventors clearly had not figured it out. And then they ended up patenting something completely wackadoodle compared to what their product eventually ended up doing. And all the competitors.
Yeah, I mean, you do have to have a little more than, well, I want to invent something that cures cancer. Well, okay, so does everybody else on the planet right now. You do have to have something more than that figured out.
Oh, that's great. Thank you guys for presenting and sharing all of this information. And for everybody that attended, the PowerPoint will be shared with all people who attended this webinar. Thank you, Ifty and Jeffrey, for your time. It's been another SEMA Future Leaders Network Lunch and Learn. Jeffrey just dropped his email in the chat. So yeah, thank you, Ifty and Jeffrey, for your time. We greatly appreciate it.
Thank you, everybody.
Thank you very much, everybody. Hopefully this was informative, and do reach out if you have questions.